Would you like me to revisit the issue of non-compliance back to the calendar call, or just please fix it? Those are your two choices.
I will fix it, Your Honor, thank you.
Does Will Water wish to fix it or go back to the issue of non-compliance with the calendar call?
When we wish to fix it.
ETT, your position.
We would like to fix it, Your Honor.
Okay, that's where I was trying to go, folks.
Okay, you're on record.
Okay, on the record, in case 831-543, Hunwardsen versus Finity Lifestyle, DBA Real Water, and ETT1 DBA Terrible Herbst. Council, appreciate Ross had the presence of jury since I had you all here early. Listening to the court, just wanted to go over a couple of the administrative things. One is, if you're calling witnesses today, we needed to make sure, because we didn't get a notification about any depositions potentially needed, and maybe because you don't need any, but we just need to have a heads up so that we can go parsing through those 10 boxes, we meaning my wonderful clerk, and find whatever depots you might need. So, Councilor Plaintiff, go ahead, Mr. Kemp.
Your Honor, I misunderstood you. I thought you meant deposition cuts. We are going to need Mr. Desautel's deposition, DSOTEL. And I don't know if they're going to want Mr. or Dr. Najim's deposition.
Let me let you finish, and then we'll go party by party, but folks, we really do need, as I asked earlier in the week, to please give us the
The only one
listing.
we would need would be Mr. Desautel.
Right, but you understand there's 10 boxes, and they're all stacked up, and so they need to be done, and we can't have a jury waiting for that. We would appreciate it. So, okay, that's counsels for Plaintiff. Real Water, is there any depositions you need today? And please give us.
Yeah, good morning, Your Honor. Joel Odou for the Real Water Defendants. Jasmine Schaefer, some of the plaintiffs. I understand she may be called today.
Okay. ETT, any depositions you need today?
If Dr. Najim will be called, then we would be
Okay. And then please for Monday, at least sometime later today, not for a list, so much easier, can you all just shoot a written list of who you're anticipated?
I can do it right now, Your Honor.
Okay, sure. Monday,
have-
you wanna do Mondays?
Yes, please.
Okay, go ahead,
For
please.
Monday, it would be Anthony Randolph, although I don't think the deposition was taken or lodged in this case, so you do not have that.
I do not recall in our listing
No.
that you gave us, Randolph, but,
No. And then Mr.
oh
Morrow.
wait, hold on a second.
Looks like Anthony Randolph.
Stephanie.
I'm sorry. I'm looking at the list. Looks like we have it in box 7.
Okay,
Okay, so we'll double check.
okay, and then Mr. Marlowe, John Marlowe, M-A-R-L-O.
And, you know, it's real helpful since you all did the listings of the boxes. To, you know, to give us, you need these, you know, and their box number, because remember, we have to take, that may be a Mr. Pepperman issue.
Yes, Your Honor, I'll have to contact my office about that to get that information.
Right, what I'm saying is, don't you already have the listing of all the depots per box, and you can just
I believe we
forward
do,
those?
I just don't have it on me.
No worries, but what I'm suggesting is, I think you already have it readily available. Can't you email to my JEA, CC to everybody else, or CC around among yourselves, which are anticipated ones you think you need for Monday and Tuesday, so we can just get those sorted and organized for you?
Yes, Your Honor, I can make sure that's done.
Yeah, okay, I'm just saying, isn't that an easier way to do it, because then everyone's on the same page, and you can each add which ones, and since you, because you all printed the sheets that said which depots were in which box. And so realistically, you know, if you forward those sheets with a, you know, plaintiff needs this on Monday or Tuesday, or water needs this on Monday or Tuesday, ETT, then we can just get those for you. And that way you all have a running list of what you have, and everyone's got the same information. If you have a better idea, let the court know.
I think that's a great idea, Your Honor, I'll make sure we do that.
So everyone has that, okay,
Thank you, Your Honor.
so,
Can I just follow up with Mr. Kemp? Mr. Kemp, is Randolph and Marlowe, will that fill the whole day?
Dr. Hudson, see you go.
Okay. I wasn't sure if you were done with those.
Yeah. Is it on?
yeah, hold on a second. I know. Yeah. Okay. Counsels for plaintiff, we don't see, what I have in front of me is what I'm calling the 10 boxes that plaintiff delivered, and it had a sealed depositions with the titles on it, that's what I'm referencing, okay? And it said which box, it said the depot date, it says the person. There is no Dr. Najim listed in any of these that I can find. Now, was that maybe listed by, is that Real Water or ET&T that you may have lodged it?
That was not ATT, Your Honor.
Okay, Real Water, did you lodge Najim?
Do not believe so, Your Honor.
Okay, well, it's going over 3, so, folks, if you're thinking, if no one's lodged it, then,
Judge, we wouldn't use the definition of our own experts when people.
Counsel, I'm
Yeah.
asking everybody equally. I asked you all, right, because you have
Right.
10 pages of written list, so we had the ability to cross-reference that. And then I'm asking Real Water, I'm asking ET&T, and they're both telling me no, so, folks, do you all have a listing of the depots you lodged somewhere?
Your Honor, Joel Odou for Real Water. We never received a list of the depositions lodged by plaintiffs, so getting that email would be helpful for us as well. The court read them in open court.
Yeah, I read them in
wrote
open
down as fast as I could, but it's always nice to make sure that we wrote them down correctly. So when that email comes, we will eagerly get it, and we will also make sure that we respond with the list of the depositions we lodged, but they were the plaintiff's depositions, so it's obviously which 5 is pretty easy to determine.
I'm just trying to do it the quickest, easiest way. And remember, what we did is, these were pieces of paper that were actually on the outside of the boxes. So we took them off, made a copy, and read them that way, because it seemed like a nice handy dandy, easy way to go through everything. So if no one lodged Dr. Najim, please don't ask the clerk to provide something that you never gave us. If you think you did, and you want to double check, please feel free to do so. But you can appreciate that she's double checking on her end, but you all, please do have a list of,
Defendants now.
pardon?
I brought in defendants, but there's one on the list.
Okay, so one just by ETT, right? Okay, so just so we're clear, with Smith, you also did a little list on your one box. Real Water's one box said the 5 plaintiffs. Do anybody need me to read the 5 plaintiffs' names? Hunwardsen, Brody, Sosa, Schaefer, and Hartshorn. That's everything that's on the Wood Smith list, dated January 4th.
Thank you,
Okay?
Your Honor.
Does Wood Smith think that you did anything more than just that one box with these 5 depots?
There is not, Your Honor.
Okay, no worries, just, so that's your box. ETT, the only thing this court's aware of from ETT, according to my clerk, is the sealed definition of Sarah Cabson, Kabsoun case, because I presumably are probably S-A-R-A, no H. Although her middle initial seems to be H. Okay, so that's the only deposition that this court's aware of that came from ETT. And remember, I read these in open court, you all have the transcript, so if somebody thinks that the court has Najim, please point to where in the transcript that you all provided it to, because we read, remember, directly from. So we'll leave you at that. They were all due on the 4th. The court, remember, there's specific rules under the EDCR. If you don't lodge them, you don't get to use them. So unless there's some agreement by all parties, or like I said, if there's an oops, that somebody says that you did lodge them with the court, please let the court know, because what the clerk did is she just went got from what we had from the time of the calendar call. Okay, so there was something, there's a couple more, those are times deposit. These are from the boxes, these are from Tracy's right there. I'm saying, I'm just making sure the parties don't know what you're bringing. These are straight from the boxes from plaintiff, correct?
Yeah, they're in
So Tracy, you're going straight from the plaintiff's boxes, correct?
whatever boxes are back there, that's.
Those
where
10
they're-
boxes that are right in
That's
the
correct.
area, okay. So the depots that my wonderful JEA brought in are from those 10 boxes from plaintiffs, so that's not new depots, just so you all wonder what she brought in. That's what I was clarifying. Okay, so that's from our end. Is there any other administrative matters? If not, I'm gonna ask, Marcia, would you mind checking to see if we have, who we have in our panelists?
Oh, so you do, sir.
Do appreciate it, thanks so much. In the interim, I'm going to ask councils, is there any other administrative, go ahead, Mr. Pepperman, you're standing up.
Yes, Your Honor, thank you. With respect to the exhibits and the exhibit list,
Yeah, go ahead.
we have several that were pre-admitted under motions in limine and several that were stipulated to or there was no opposition during our meet and confer on the exhibits. Those are all indicated on the list, but it's my understanding that we need to do something else on the record to actually make sure that those exhibits are admitted.
Okay, so let's circle back. When you say the list is when, at the time that you provided the electronic exhibit drives to the vault, you also provided an exhibit list that had the groupings of exhibits allocated to each of the parties, which is your unnumbered, I'm just gonna call it a multi-page list because it's not paginated. Okay, is that what you're referencing on, is that the list? Because it doesn't have it's a trial date of 1/16. I'm just trying to make sure we have the most up-to-date list is where I'm going. And since it doesn't have a footer, it doesn't have pagination, it doesn't have any date on it, I just wanna make sure I'm looking at what you think I'm looking at.
We submitted the joint exhibit list to the court as part of our joint pretrial memo. I'm not sure if that's what you're looking at or.
The reason why I'm asking that question, when I'm looking through said list that was given to the clerk by one of you all's teams, okay? And I'm looking at that, and I'm looking at a column that says stipulated yes and no. I am not seeing that any of them say stipulated yes or no. So if you want to approach, let me put a clip on this to make sure. This is the only thing that the clerk was provided that we are aware of, so.
This is Defendants, and I have ETT.
So this is plaintiffs?
Yes.
Okay, so plaintiffs, if you want, you can approach, you want to take a look. So sort it back with your stuff. That's the only thing that was given to the clerk. It was given at the vault at the time of electronic exhibits, what was relayed to this court, so
Okay, so we submitted a joint.
it can't be attached to a pretrial memo, as you know, it has to be specifically submitted in accordance with ADCR 2.67 and 2.69 when you provide your and the electronic exhibit protocol. The official one is the one that's given to the vault because that's you all stating to the vault that what's on the drive is what's on the list. This
Okay.
list is what the vault has represented to the clerk, is what you all, meaning plaintiffs gave, is what I currently have in my hand, and separate ones from the other two parties. So, is this the right one or not?
Mr.
That-
Pepperman, can you just move the mic? I can pick it
Sorry.
up, not you.
This is Defendants?
The smaller one is ETT.
Okay. Yeah,
So that is what was submitted to the vault, Your Honor, but that version doesn't have the indications of the pre-admitted or stipulated exhibits. So that is, I guess, what I'm trying to raise is what do we need to do to indicate to the court those exhibits that have been stipulated to be admitted?
we need an accurate, updated exhibit list from each of the parties. So what you all submitted to the vault is not the accurate, updated one. We would need the accurate, updated one from each of the parties. I will tell you, it's so much more helpful if you paginate it. So if you're referencing, right, the court's not having to flip through 20, 30 pages to know which page you might be referring to. It's helpful to do. It's also helpful, you want to put some kind of indication, whether it's in the upper right-hand corner, down at the bottom or something, that it's the date, right, okay, or includes stipulations, so that we just know that we've got the right one, and the most updated one. Once again, I go back to the lovely crystal ball, I don't, So you're telling me what was submitted to the vault is not the most up-to-date one, is that correct?
That's the most up-to-date list, it just doesn't have the indications of what was stipulated to be admitted or
Which means
pre-admitted.
it's not the most up-to-date list, because as you know, you have to provide with said stipulations, that's why it has the column. So please get the court an accurate, updated list. Please, I'm sure it takes about, any reason you can't put pagination on it, spend 1 minute and add in insert pagination.
No, Your Honor, I'll have them
Okay.
paginated.
Do I have the same issue with real water? Because we don't see any stipulations on any of your exhibit listing.
Majority for real water, that is correct. When, at the time that the vault accepted the exhibits, there had not yet been an agreement as to which exhibits would be stipulated to. That's why the list from the vault is not updated. The parties met and conferred for several hours, went through all the exhibits in the case, and we will make sure to get with plaintiff's counsel and get the court the stipulation on the exhibits that have been admitted with the right pagination and all exhibits.
Right, it basically, you know, to fill in the column if it's stipulated, right, by the
Yes.
parties is, please put a little X, smiley face, whatever you want, just something that
Will do,
indicates.
Your Honor.
Okay, okay. ETT, same issue?
Yes, Your Honor, I'm looking at the list. And we
Mr.
do not-
Ross, do you have a mic by Kemp? Thank you.
Sorry, Your Honor, Valerie Rojas for ETT. Yes, we need to fill that in, Your Honor.
Okay.
I can see it on our list.
And if it's easier for the parties, if you want to do it as one master one that has a breakup, you know what I mean, that, look, pages 1 through blank, you know what I mean, with a clear indication that these are plaintiffs, and then starting at, you know, page blank, you know what I mean, is Real Waters or ET&T, we don't care whichever order you want to put it in, okay? Now, you may want to put them in the numeric order, which means it would be plaintiff, Real Water, then ETT, based on the agreement of the parties, but, okay, we just need it so that if somebody's referencing something, we make sure we're on the same list that you are on so that we can get you all taken care of, okay? Does that answer your question? So the easiest way is to get the exhibit list. I have to see it with the stipulations, and then we'll confirm to see if there's anything else that needs to be done.
Yes, Your Honor, I will get that to the court today, as soon as we can. In the meantime, if we move into the witnesses, I can, before we start, let the court and the court clerk know all the exhibits that we plan to use for that witness that have been stipulated to admit. And then my last question is if,
But counsel, I'm gonna stop here 1 second. Is the actual exhibits in these documents that I have exhaustive, and is it just an issue? I was politely trying not to say if there was other issues, really giving you a chance to fix whatever the other issues are, if there are any more, but is the only issue that it doesn't indicate stipulations and pre-admissions pursuant to motions eliminated, or are there potentially other issues in these documents that may have been updated from the time you gave it to the vault? That's the reason why I was just kind of saying, could you just make them the most updated, accurate, in case there's other issues that,
do you mean additional exhibits?
I don't know what changes you may have made, so that's why I'm saying it in a global sense of, please ensure it's the most updated, accurate, because I don't know, because nobody's told this court that you've done anything different, so.
That list has all the electronic exhibits that have been submitted to the vault and that we have.
Sure.
The only thing missing from that is the stipulations that we've admitted or that have been pre-admitted.
Okay. So if that is the issue, I think what the challenge is, the clerk can't have 2 sets of exhibit lists. Okay? Because you can appreciate she would be working off of one, and then you'd ask her to get a new one. So that's why that really should be a #1 priority for someone at your team in the background during openings, right? To get these with the stipulated for any witness, right? Because the point is, we need to work with one exhibit list. We can't have multiple versions because it has to be the official copy, right, that goes back for purposes of preserving your record. Otherwise, you're risking, right, having different documents and not having a clear record, which I don't think, given all the time and expense you all have done in this case, that anybody wants. But if you want to mess up your own record and have multiple potential exhibit lists, then I need to hear that on the record as a stipulation under EDCR 7.50. Is anyone going to make that stipulation? I'm seeing negatory nods. You understand, I'm just saying. That's why I'm trying to emphasize the importance of getting this to be accurate, because it was supposed to be accurate with a specific copy provided to the court at the time of the calendar call. We're not going back there, we just need you to please fix it, everyone, so that we have one exhibit list for purposes of your witnesses, so that the clerk can utilize that as your official exhibit list to ensure you get a nice clear record, okay?
Your Honor, then maybe perhaps the quickest resolution to that is to use the list we have and as
No,
we...
it's not, counsel. I was very clear, please fix it,
Yes, Your Honor.
okay? Thank you so very much. Would you like me to revisit the issue of noncompliance back to the calendar call, or just please fix it? Those are your 2 choices.
I will fix it, Your Honor, thank you.
Does Real Water wish to fix it or go back to the issue of non-compliance with the calendar call?
Odou, we wish to fix it.
ETT, your position.
We would like to fix it, Your Honor.
Okay, that's where I was trying to go, folks, but come on. Okay. So, we have a jury that's outside, about ready to go. Do we have any other administrative issues that you would like prior to the jury coming in? Okay.
Your Honor, may I have your permission to step out and,
Oh, you don't need my permission, I've already said people are perfectly fine, we've already told the jury people are gonna be coming in and out.
thank you.
You're more than welcome.
Could that be that?
Wait, hold on a second.
I need the names, all the names.
Okay, we can't have your law firms calling my JEA and saying to add different things than people are saying in open court. I'm not gonna say who's doing it.
Judge, I think it might have been a name set.
Okay. We need to be clear on the record, folks, okay, what you wanted. I have a wonderful JEA who's assisting with all cases on my docket, okay, in addition to, she's trying to cover her phone for search warrant duty to give me messages. I'm also on search warrant duty in addition to this trial, 24/7, so you can appreciate, I appreciate you all maybe diligently trying to have your teams do things. There's one person trying to do a lot of different tasks. Please do not overtask her. If you have any questions, I'm right here in open court. You feel free to ask me, and then we can delegate things so that everyone has an opportunity to get the things that they need to get done, okay? We do appreciate it. Bring off the record for a moment while we wait to see if all the jurors are here. Appreciate it. Thank you very much. We are back on the record. Mr. Kemp, did you have a question? Go ahead, please.
No, Your Honor, I just wanted to alert the court that Dr. Notcham was here in the courtroom and just attended to have her for expediency. We know she's through that with violating the exclusionary rule because he is an expert, and so I just wanted to make sure of that.
Let me find out. Court has no position. Let me find out if the parties do. Will Water, any position?
Your Honor, we have no objection.
ETT, any position?
Valerie Rojas for ETT, we have no objection.
Okay, thank you. And perfectly fine, whatever you all want. Okay. It looks like another box got dropped off at another date, so my JEA is now trying to look through that box to see what depositions. We did find, she found one. So, it appears to be Najo. So, we are looking to see that. Look at it. Are all these depots original sealed depots, or does the court need to address that any of them are copies that parties have agreed that can be used in lieu of originals, or to your knowledge, are they all originals without the court going through each other on them?
I believe they're originals. I can't say that they're all still sealed because we have copies sealed when we got out the case. I just can't read it. I don't think we did, but
So let me cover that one. If any of these are already unsealed because they were previously used in the Gallagher case, are the parties okay, or is there any issue the court's going to need to address?
Joel, do for Real Water, we're okay with that.
Do you have the list?
Valerie
What's your
Rojas
copies?
for ETT was on that.
Okay,
Where's the names?
sorry, hold on a second.
Here's the names.
Pause just 1 second. People want to be multitasking, so don't mind. Rojas, would you mind repeating?
Yeah, I was just saying that we agree with the use of Dr. Najam's deposition, even if the seal's broken, because I understand he testified in Gallagher.
I was trying to just ask the question a little bit more globally. Once again, we've got 10 plus boxes, right? We've listed, we've looked through to, do the things, and we went on the record with things. Did we go through to see if everyone is actually 100% sealed? No, because there'd be no reason for the court to do that. So I'm just trying to anticipate, if any of them are unsealed, do parties want to prospectively say, as long as it was lodged with the court, that they're fine to use for purposes of the trial, or does somebody want the court to address something? The court has no position, I just need to know what you all's
we're
position.
fine with that now.
Real Water agrees, Your Honor.
ETT agrees, Your Honor, I'm fine with it.
Yeah, it's just an easy way to address that. If somebody has an issue, just let me know. If you don't, it's fine. Marshall, we have all of our,
We've got them all, Judge.
okay. Is there any other administrative matters? Are you ready to bring the veneer panel in?
We're ready, Your Honor.
Is ET's ready, Real Water ready?
We're ready, Your Honor.
Okay, and Plaintiffs, you ready as well?
That's right.
Okay, Real Water, you're gonna be doing your opening. Do you need the podiums moved for you? turn around, or are you using the small podium?
I can use the small podium.
We can-
Is this,
We can turn a big podium too if you want, just tell me what you want.
this one?
I think so, but because you're in front of that mic.
Okay, and so remember we walked through the same guidelines just to make sure all of our jurors have their personal space, okay? So do you need anything from a prep standpoint, or is it okay to bring the jury in?
No, we can call. Yeah, can we just go ahead and pull the power from it?
You just need to check it. Okay.
Make sure my little clicker
Yeah,
works.
no worries.
Okay, I don't know if that's on, Mr. Love.
Oh.
Is it on? Yeah, I didn't think so. Okay. There you go.
Just a problem. Makes me feel better.
Are you all right?
We are ready, thank you.
All right, so President Jerry.
We're seeing a couple people looking towards that jury card, which I'll explain in just a second. Okay. Well. May we all be seated, Marshall?
Please,
Appreciate it, thanks very much. Well, welcome back, ladies and gentlemen. Hope everyone had a nice relaxing evening. Welcome back to trial. So, mentioned yesterday, there's a couple things on the jury cart. You might have noticed there's a small brown box. So here's my disclaimer. Yes, I've brought in some donut holes. They're just glazed donut holes. If you want them. The court takes no responsibility for, let's put it this way, whatever ingredients are in said donut holes or whatever ingredients are in said donut holes, you're welcome to help yourselves to them. The court takes no responsibility for anything if you should or should not be doing so, okay? Just trying to give you something. It's Friday, so there's some napkins and little donut holes. If anybody wants any, you're welcome to do so. If you don't worry, I'm not offended, so, okay?
Thank you, Your Honor.
You're more than welcome. Okay, so as we told you yesterday, that when you came back today, we will be continuing with opening statements. And so Counsel for Real Water now has an opportunity to do their opening statement. Counsel, feel free to proceed.
Thank you, Your Honor. Good morning, ladies and gentlemen. My name is Mark Love, and along with my co-counsel here, Joel Odou, Eric Freeman, and Matthew Kaufman, we have the pleasure of representing Real Water in this case. And first of all, I just want to start and say good morning. Thank you, everybody, for coming back. I know you have no choice, but we appreciate you being here. And I just wanted to start off by telling everybody, Real Water has admitted liability in this case. The Real Water Company set out to make a healthful, alkalinized water product with antioxidant properties. They were proud of the product. Everybody with Real Water drank it themselves. And there was no expectation that a chemical called hydrazine would be found in the water, but it was. And so Real Water is stepping up, taking responsibility, and is deeply saddened about this occurrence. They apologize to each of the plaintiffs. They apologize to each of the individuals throughout Southern Nevada that was made sick by their water. And like I said, they're going to take responsibility and admit liability for these cases. So this is really 5 cases in one, and we're asking you, ladies and gentlemen of the jury, to listen to the evidence as to each of the 5 different plaintiffs. Real Water is a defendant in all 5 of the plaintiffs' cases. There's another defendant in this case that you'll hear from, Terrible Herbst. They're only in one case, Myles, Hunwardsen, whereas with Real Water, they're in each of the 5 cases. Because we're not contesting liability, your job, ladies and gentlemen, is just to assess the damages in the case as to each of the plaintiffs. Each plaintiff has their own individual case facts, dates of when they consume the water, medical costs, and so it'll be your job, ladies and gentlemen, to keep each one separate. Real Water was started in 2008 by Brent and Amy Jones, and then Brent's son Blaine was hired on as an employee when they began and worked his way up to vice president before stepping down in 2020. It was in essence a family business, although they had a number of employees, and you'll be hearing from a number of their former employees in this case. They believe in their product, they drank the product, they thought it was a healthy product. The core of real water is the concentrate, which is called the E2 concentrate. It was invented by a man named John Marlowe. I expect Mr. Marlowe will be a witness Monday, and you'll get a chance to hear from him. He considered it proprietary. He invented it and licensed it to Real Water. And then in 2011, Mr. Marlowe taught the Real Water people, Brent and Blaine, how to make the concentrate themselves. You'll hear from them, you'll hear from Blaine in this case. They made the concentrate the same way from the beginning to the end for a decade. Now, the process is a little bit complicated. They started with regular city water, and then they purified it. They ran through multiple steps, including reverse osmosis, carbon filtration, ultraviolet treatment, until they got to a very pure form of water. At that point, they added potassium chloride to the water. And potassium chloride is a salt, and you'll hear a little bit about that, but a salt is basically a negative and positive ion that are combined together, usually forms a solid if it's dry, and if you add it to water, it'll break up into its constituent ions. They added potassium chloride. The most common salt you hear about is sodium chloride, which is table salt. The potassium chloride is fairly close relative to that. So by adding the salt to the water and having the ions break up, it would carry a charge. They then put 2 titanium rods into the water, charging one with a negative charge and one with a positive charge. So you had a cathode and anode in the water, and that would cause a separation of the negative and the positive ions, the negative water and the positive water. And what they did was they would split the water in half, keep the negatively charged half, and then dispose of the positively charged half. So you start with 300 gallons, get down to 150 gallons. They then would do it a second time and get down to 75 gallons. At that point, when they have 75 gallons of the negatively charged water, they added additional minerals. Again, you have magnesium chloride, potassium bicarb, and potassium hydroxide. So they added these salts. Potassium hydroxide is actually something called a base because it has a hydroxyl component as its negative ion. It actually causes an increase in pH, or increase in the base level in the pH, or alkalinity. So the potassium hydroxide was added to shift the pH into the alkaline range. Then once they had the concentrate, they would use 2 to 2.5 gallons of that and add it to 300 gallons of purified water, and that would be the finished product, and that would go to bottle. Here's a couple of the tanks. This is from the concentrate making process, the actual tanks that were used at Real Water. So in 2021, there was an outbreak. Several people came down with liver failure, and the CDC got involved, and they started doing an investigation. They eventually determined that the one common denominator was Real Water. They sent it to a lab, and they spent 5 or 6 months doing various lab tests to try to figure out what of thousands of things that could be in the water, what it could be. And eventually, after running test after test, you'll find they isolated hydrazine in the Real Water product. Hydrazine, as you can see, its structure, I don't know how many of you have had chemistry, but it's a pair of nitrogen atoms that are single bonded, and each nitrogen atom can bond 3 times, and so it's 4 hydrogens with 2 nitrogens. It's somewhat related to ammonia, and at high levels has a bit of an ammonia smell to it. Hydrazine is a liver toxin, and it's simply something you wouldn't expect to find in a food or beverage. The FDA doesn't require testing for it in food or beverages. Now, if we look at the material that Real Water was made out of, you start with pure water, which is a hydrogen, which is a proton, with a OH, which is a hydroxyl unit. So it's H2O is water. And if you look at the various additives to the water, none of them contain nitrogen. So it certainly wasn't expected that there would be a nitrogen-based compound in this water product. And it's quite a mystery as to how a nitrogen product could end up in the water. We will hear later today from Dr. Najim, who's here in the courtroom. He has come up with a pair of hypotheses of how it might have appeared in the water, and we'll get a chance to talk to him a little bit about what those pathways might be. But you'll hear it was quite surprising that it would be in water that didn't have any nitrogen-based products in it. You'll hear from Blaine Jones in this case. I expect by recorded prior testimony. Blaine was Brent's son and worked in the company. He worked his way up to VP at some point. Blaine is one of the individuals, Blaine and Brent, that made the concentrate. We'll hear from Blaine that he made the concentrate the same way. It was made the same way from the beginning for a decade. We'll hear from Blaine that they hired an FDA consultant expert when they started the company to make sure that they did the correct setup, the correct testing, that they were fully compliant with regulations. And you'll hear from Blaine that they tested as required. You'll also hear from Blaine that he drank the product, just like his father did. Blaine drank 2 to 4 liters a day. You'll also hear from Blaine that in October 2020, he actually got liver failure himself and still did not connect that liver failure in any way to real water. It wasn't until so that was in 2020. It wasn't until 2021 when they discovered hydrazine that Blaine had ever even heard of hydrazine. Okay. So as you've heard several times already in this case, your job, ladies and gentlemen, is just to assess the case for damages and to determine whether punitive damages apply. You need not worry about whether there's liability or isn't liability. We've already stepped up and accepted that fact. So I have here on the board the plaintiff's past medicals. These are dollar amounts from the past medical workup each of them has had. We have agreed to these numbers. We're not disputing them. So that's sort of the base starting line for each of you, and it's up to each of you, ladies and gentlemen, to assess the evidence and determine what additional damages, if any, are appropriate as to each of those plaintiffs. Now, keep in mind, plaintiff does have the burden of proof. I don't know where the little scales went, but they need to demonstrate more likely than not as to the evidence for the compensatory damages. And because plaintiffs have the burden of proof, they get to put on all of their evidence first before the defense gets to put on any evidence at all. So we ask you, each of you, ladies and gentlemen, to wait and hear all the evidence before coming to any conclusions. It's like working a jigsaw puzzle. You don't want to shake out half the pieces and just try to start building the puzzle with half the pieces. You want to get all the pieces out of the box, all the pieces face up, before you start really working through and building the puzzle. And we ask you to do the same here. Now, another component you're going to be asked about is punitive damages. And the burden of proof is different for punitive damages. You have to assess whether or not punitive damages are appropriate as to real water in this case. And plaintiff's burden there is clear and convincing. So they need to put on more than just more likely than not. They have to put on clear and convincing evidence that real water acted in a way, and I have some magic words on the board, but real water basically acted with malice or conscious disregard. They need to demonstrate that real water, did something that falls into one of those categories. And the judge will provide you a specific instruction when we get to that point on how to get to that. But ladies and gentlemen, once you've heard all the evidence in this case, I believe you'll agree with me, the plaintiffs need to be properly compensated, and we leave that to you, but I believe you'll agree that Real Water was unaware of hydrazine being in their product until 2021, and therefore punitive damages aren't appropriate as to them. And I just want to close by again saying, on behalf of Real Water, we apologize for what happened, we accept responsibility for what happened, and our heart goes out to each of the plaintiffs and each of the individuals that got sick. Thank you, ladies and gentlemen.
Appreciate it. So, since Council for Real Water now has had an opportunity to do their opening statement, we now would go to ETT1, DBA Terrible Herbst. Would you like to commence your opening statement?
Yes, Your Honor.
Feel free to do so. And just to let you know, you did have a changing of the microphones. It'll take just a second.
Turn it off.
Wow, with our pocket microphones, it's funny. One of them, it has to be green, one of them, it has to be
It's on
red.
the top.
Just like you notice, they have red lights, and these things are on, and
Okay, I'll be able to hear you now. Thank you.
so just give council a few moments. If you need anything, feel free.
Thank you. Appreciate it, Rick. Good morning. Number one, I sincerely thank all of you on behalf of our team. We have Val, Ms. Rojas and Val, and Dan White. So thank you very much for coming in, for being part of the system. When people first hear about jury duty, they try to run and hide under every possible place. But if you have the opportunity to serve, people really think it's one of the great places where you truly work together to come to an important part of our justice system. And so I hope you find this really rewarding as well. It's really important to all the parties. I'm also honored to represent Terrible Herbst and Chris Kemper, who and you'll get to meet some of the other people. And it's a true honor to be with them and to represent them. I'm also really grateful and proud to be a lawyer and be able to present cases. And you've had people so far, I think all the lawyers in the case are very fine lawyers, and they're all trying very hard on behalf of all their clients. Let me talk about all of the witnesses for a moment, because I just mentioned the lawyers. The lawyers are used to doing this, so they come into court and they're very comfortable here. Some people are very, very comfortable here, really like the new process. Some a little less. Some are still, regardless of how many years you do it, some are a little nervous as they do that just like you. If you remember when you were first in jury selection and when you were watching the other jurors, sometimes it was a little nervous as you were being questioned. And the experts that come in, a lot of those people testify regularly, and so they're pretty comfortable in the courtroom as well. And a lot of the other witnesses, we call them lay witnesses, in other words, not expert witnesses, a lot of them don't come into court. A lot of them have never been in court. And so for them, they have a little of that same nervousness that you saw. On the other hand, you judge them just like you do everything else in life. You judge them the same way you do the rest of your life. And you use what my dad told me. My dad had a 9th grade education and eventually bought a repair shop and that. And one of the things that he told me was, you got to have walking around sense. You know, in other words, common sense. In other words, you walk around as you're doing your life, you got to have sense about it. And that's the way you have to look through, not the arguments of counsel, because in the end, the arguments of counsel on all sides, including me, not evidence in the case. The evidence is the actual witnesses on the stand. And then you have to wait too, because the judge at the end is going to give you the law. So I just heard the one story here, and I heard an earlier story that we all try to tell you on how to wait. And so I have 2 daughters. I'm a father with only daughters. I always swear I'm going to write the book, but I don't have enough things I don't get done. I'm not going to be able to write the book on it. But
one of the things that happened is one daughter would come in and talk to my wife and me about the other daughter, and I think, why would that kid do this thing? It was just unbelievable. So we go back and eventually hear from the other daughter, and you go, well, there was usually a little bit of truth to it, but there's like a whole other side. So again, until you've had the chance to hear from both daughters here, in other words, hear the case through, please keep an open mind. The next is, in the jury selection, it went days on one side and about an hour here or there on the other side. And one of the things you were asked was, is it okay if somebody speaks less? And is it okay if they speak more? You can do either. It's a free country in that regard. But the thing I ask you is, because I'll speak for a little bit this morning, I have to tell you about what the case will show so that when you have the opportunity to listen to the witnesses, you kind of get a sense of what the puzzle is like. We give you a bit of the picture, so as you're getting the pieces, you know where they go. But I'm going to be very short. Val's going to be very short. If we have something to say, we kind of wait and just say it. We don't say it over and over and over. So if you're going to, we did ask if we kind of just stay to the point, please give us the same consideration for being short as you might give somebody else for taking a longer time. I was listening to the movies part. So my movie is Top Gun Maverick. And so the aging pilot tries to go in and save the country. And so I'm thinking, I'm picturing me grabbing onto the wheel on behalf of my client. And you're all thinking, well, he doesn't look like Tom Cruise at all. And so if Tom Cruise, though, had like a boxer or a bulldog, I could look like Tom Cruise's dog. So I'm in there, I'm ready to go. With regard to the compensatory, I'm really not going to address that. My client, ETT, has responsibility as a seller for compensatory damages. That's the end of the story. So there is nothing further for me to address. The kind words mentioned by Mark, I say the same. Truly sorry to anybody for what they've gone through. Nobody should have to go through that. We were a seller. We didn't know any of this, and it's going to be important as I now switch to the punitive end. It's important that you separate out whether or not the product was a defective product and was manufactured and sold. That's the compensatory side. The other, though, on punitive is much different. And that is, was there actual knowledge of the probable harmful consequences of a wrongful act? In other words, was there knowledge of what would happen and a failure to avoid that? Was there malice or a vile act? So when you look at ETT, which is the Herbst family, that's Ed and Tim and Troy, so that's the ET, wondering what the ETT is, it's the three Herbst kids. There is nothing that was done that was vile, malicious, intending to cause harm to anyone. And I'll go through the facts on what and why I say that. First of all, Terrible Herbst has history in Vegas back to the 50s. The name Terrible was because when Herbst came into town, somebody else says, when he comes in, it's terrible. He's going to try to steal the business. So the model was kind of give stuff away with the gas. And so initially, they gave boxes of sugar away when they were selling gas. And eventually, it moved to balloons, and then sort of the latest that you still seen on the screen is the free drink. So when you go to a Terrible Herbst and you do a fill-up, there's usually a fountain drink, so you can get coffee or pop, and then there might be a packaged good. In this case, the real water was one of the things you could go in. If you didn't want a fountain drink, you could get a bottle of water from real water free. So you had the opportunity for a free drink, something you don't usually get. And it continues after all these years to be a competitive advantage for Terrible Herbst when you come in. They're active in the community and participate in Chet Buchanan's toy drive. Terrible Herbst and Herbst and...
I'm sorry, Your Honor.
I understand.
No, not Tom and Jerry, please, if you'd like to approach, Madam Clerk, approach it on white noise, thank you so very much. One council, please, serve the roll.
Thank you.
Appreciate it. Sorry for that interruption, ladies and gentlemen. As you know, we do white noise all the time, okay? We've got to address issues right away. I presume you didn't want to keep going in and out, so thank you so much. Thanks for your patience. Council, sorry for the interruption. At this juncture, there's nothing the court needs to do specifically, so please feel free to move forward.
Thank you. And ETT has been an active part of the business community in their stores now for, I believe, close to certainly at least 70 years. And what they did, they sold here amongst 16,700 total SKUs. Some of you will know SKUs, some of you may not. Basically, as a SKU is any product with any variation. So in other words, here if you have bottled water, there's actually 4 SKUs on real water, and the 4 SKUs are just the different sizes of real water. But in total, there's 16,700 different SKUs within a store. So Terrible Herbst sold real water, as did drugstores, grocery stores, and convenience stores, both around the country and in the area here. Our actual personnel, you heard the one comment by Plaintiffs' counsel, was that they gave him free water because he's the buyer, so they give him different samples of stuff. He was drinking the real water throughout the time frame here. His family was drinking the real water. The employees were all drinking the real water. They had no idea, because the question is their knowledge or something that they're consciously disregarding. You'll find they actually drank water themselves. There were no complaints that we're aware of directly to Terrible Herbst. Some people did make some complaints. You heard about bottles. Those are complaints that were made to real water. So if somebody had a problem with the real water, they took the real water issue to real water, not to Terrible Herbst. So we're not getting complaints about that. We have no knowledge of this chemical that somehow was not something listed on the bottle. It's something, the hydrazine is apparently caused somehow in this process, and nobody at anywhere near Terrible Herbst had any idea of that. Apparently, neither did people at Real Water at the time, don't really know. Apparently, neither did the FDA or anybody else. So let's go now to this particular situation, the Real Water. So this is Terrible's. Most of you will have, because they're all around town, whenever you need gas, whenever you're running in for something for convenience, you may well have come into one of the stores. Here shows you some of the different products that we have. I believe every store now has the pop machine, soda machine, different people call it either pop or soda. It's the big machine there. It's got the Coca-Cola on it. And Mark Walters is very proud of that because you get 260 different flavors out of one machine. So you go to a convenience store or to a gas station or you go to Costco and you put your bottle up against the 8, maybe 10 flavors in total. When you go to any Terrible Herbst, you get 250 different flavors in one machine. These are the sorts of things that a convenience store is trying to do, because the idea behind a convenience store is to give you as many different products as possible, and there are usually only a couple of them. So in other words, if you get M&Ms, you get one little box of it, you get whatever else is in. The idea is you want to be able, from a convenience standpoint, go to one place and nab something quickly so you don't have to go to a grocery store or to a larger store to do a wait in line. There was the photo in the end that you saw. Remember the red, the little beaker, and it said top secret. It was one of the things that Mr. Kemp, I think, put up. Well, it's top secret at the Real Water end. It's not top secret. We don't know what's in the top secret. The whole idea of the products are they have proprietary stuff in them that we, just as a seller of 16,000 different SKUs, would sell. And actually, when Mr. Kemp was talking about this. He was talking about, and I'll get into this in a little more detail later, 2020, what was occurring, people were continuing to drink this in 2020. Blaine Jones, you know, I'm going to flip this over to Mark, because Mark will be able to find, there we go. Mark, if you, can I give this back to you? Bring up the Blaine Jones, if you would, please. Blaine Jones, in 2020, was actually causing harm to himself. He was the guy that was mixing this at Real Water. Nothing to do with Terrible Herbst itself, but at Real Water. And he actually gets ill in late 2020, and that's when you heard about Mr. Kemp telling you, well, gee, they tried to get together and the employees were telling him, do something about this. And nothing happened. And he went through, he went October, November, December, etc., all the way to March 16th of 2021. Let's flip to, if you would, Mark, to March 10, the email from March 10. So let me give you, as they say on the late night shows, they give you the setup for the next, we're going to show you a little clip from the movie, so here's the setup, this person's dating that person or whatever. The setup is, the first time that there's real knowledge of all of this is on March 13 of 2021, the Southern Nevada Health District, so 3/13/21, Southern Nevada Health District, the Nevada Department of Health and Human Services, the CDC and the FDA launched a public health investigation. So this is 2021. We then received, and I'm going to go into this in more detail later, but there was talk about how much dealings we had, that Terrible Herbst had with Real Water. Terrible Herbst did not work directly with Real Water. Real Water didn't send a truck over and send water in. Mark, would you mind flipping to the slide that has the three boxes that's got the Nevada beverage in the middle? No, the three that are, there you go. So when Terrible Herbst would buy water, they would buy water from a major beverage distributor. And in this case, it's Nevada Beverage. Nevada Beverage is actually, you'll hear during the testimony, one of the 10 largest Anheuser-Busch distributors in the country. So it just tells you that, I say that there's no Anheuser-Busch thing involved here. I'm telling you that only for the size of the outfit that we deal with. So, and we get all kinds of waters from them. We get other products of other types, and they're a beverage company. So it was both, anything alcoholic or non-alcoholic would come through Nevada Beverage. So now let's flip back to the March 10. On March 10, Nevada Beverage sends an email to Mark Walters, who's the head of purchasing. And it says, Mark, we have received reports of alleged health concerns regarding Real Water. So 3 days after the joint investigation, CDC, FDA, and et cetera, we get a notice from Nevada Beverage. For this reason, we are stopping, there's a health concerns, alleged health concerns, and for this reason, we are stopping delivery of all Real Water products until further notice per their CEO. And we will also be recalling all of the Real Water products in the stores. So we're hearing from Nevada Beverage that they're going to do a recall. And you heard in the openings for context as you're looking, in the jury selection for context, the question on all this is, what did they know and what did they do about it? And you heard, for examples, the Ford Pinto or the cigarette manufacturers. So now the question is here, when Mark Walters, or Terrible Herbst, was notified about, it just says alleged health concerns and potential to recall, what does, so this is what did they learn and when did they learn it? They learned on March 16 at 6:10 in the evening. So this is in the off hours that there was an alleged health concern. Would you bring up the next one, please? Mark Walters, within 14 minutes, sent a note to his boss, sort of head of all operations at Terrible Herbst, and says, Matt, can you send to the team and let them know to remove all product and hold for credit? So within 14 minutes of this being sent, not when he saw it, we don't know when he saw it, but we know that the most amount of time from when it was sent from Nevada Beverage, the distributor, to us of an alleged health concern and a recall, we sent the note out from the head of of all administration to let him know. So what does the head of all administration now do when he's told we need to remove all the product? Next up, please. 3 minutes later, he sends a note, the head of all administrative ones. So all this is just in a random evening at dinner time at 6:27. 17 minutes after the first notice by Nevada Beverage of any problem, it says, this is now sent out to all the district managers for the stores. Please read the below correspondence regarding real water and the corrective action that requires you and your team, immediate action. So within 17 minutes, I was actually going to turn a timer on, but I don't want to be hokey. You know exactly what 17 minutes is. That's a really, really fast response. The next morning, so already some of the C-store managers were starting to pull it off the shelves that night. The next morning, Mark Walters called each of those managers individually to make sure that they either had done it, started it, or were getting it done immediately. And then, by the way, you heard a couple of bottles slipped through. You were told by counsel for the plaintiff that, I think it was Teddy that said this one. He said, you were selling 371,000 bottles over 2 years. So let's say roughly 185,000 bottles a year of water. 4 bottles apparently showed after that. In other words, out of it's rounded off at a different place, 200. So I'll just use 200,000 in a year. Out of 200,000 bottles, they stopped 199,996 from going anywhere further and got them packed away and out. Now, does that mean 4 individual bottles that even got sold? No, it doesn't mean that. It means they could have, but it just could have been a skew. In other words, if something got either cut a skew or it got damaged or whatever, it could have been a misread. All we know is when the message first came, immediate action within 17 minutes, they cleaned them all out, and the most anybody can find any time after that is just a possible skew of 4 bottles sneaking through, if they did, out of 200,000 bottles. That was a 99.99% success rate of getting that off. Does that show vile disregard and malicious conduct? No, it shows about the fastest you could possibly imagine. Had I asked you instead of showing you, and I don't get to have a dialogue now, we have dialogue during jury selection, but if I had asked you how long, when you first got notice, assuming it's off hours, how long do you think it would be before action would be taken? I don't think anybody would have guessed as short as 17 minutes. And it's 17 minutes to get it to the guy's boss, and the guy's boss get it out to all the district managers. The next one was, nobody did, would you flip to, there's a store toward the back, there's a little wider pan of the store. In fact, let's go to this, okay, this is great. This shows you one of the stores inside. It also gives you a sense of why there's so many SKUs. If you look up at the Pringles, I eat those. As you can see, there must be some excuse for why I look like this. But so I hit into the Pringles. Well, there's like, a little 1 or 2, like 2 of each, so that the idea is, if you want a green onion or whatever and sour cream, you got one of those. You want an original, you've got one of those. You want barbecue. And the same thing for all the different products. And they say, well, there's some duty to do, did you ask for audits or do audits on each of those products, the 16,700 SKUs? There'll be less products because there's multiple SKUs. In other words, the real water had the 4 sizes. So you'd come back down. But I think our expert, Dr. Atchison, will testify that Costco, for example, has about 6,000 SKUs. We have 16,000. We have almost 3 times as many SKUs as Costco. Well, why? Look at one of our stores. You don't decide it's a convenience store. You get a huge Costco next to it. Different concept. One, Costco's got a small number of products, and they have a huge amount of it. So you go and you put toilet paper and whatever else in, and you buy, 12 or 24 rolls and all the rest of that. That's not why you have here. And realistically, our expert, Dr. Atchison, will say, no. Very few of any stores, convenience stores, grocery stores, drug stores, would go out and do individual audits on all their products. You'd have, in this case, 16,000 different products and 16,000 of these. What do we do to try to assure the best that we can, Terrible Herbst, when you come into a store, that you're going to be protected? And the answer is you work with a major distributor, in this case Nevada Beverage, and for the most part you're working with national brands, both of which were the case here. Let's go to the SKU slide that's got the different products. I want to give you a sense of, let's stop here as we're doing this. This gives you the different sizes that were sold at Terrible Herbst. Let's go to the 5-gallon then, if you would, please, Mark. I couldn't do this. If I kept that any longer, we'd have gotten nowhere on the slide. So, Mark, thank you. It is a part of our team, an important part. Flip to the SKUs, the information on all the different products. Okay, so I told you about the 16,000 SKUs. The number of beverages sold in Terrible Herbst stores, if you take every variation of every type, is 3,400. The number of water brands like Dasani and Aquafina and all the rest of those, there are 55 different water brands. And, okay, here we go, Smart Water. A few of the others you're familiar with. By the way, those are some of the major water brands. Real Water is not a top 5 or top 6 water brand at Terrible Herbst. There's a lot more that have more volume than that. So the idea is that we're some sort of marketing arm for them. Doesn't really make sense when we're selling all the other bottles. And if you're called a marketing arm because you run an ad on the pump, and the pump's got all kinds of ones. So it says, buy this stuff, whatever, buy the next. Terrible Herbst doesn't make those ads. The different companies say, we want you to put an ad on to help market the product. And then a lot of times, like one of the situations I think you saw here, there then was a free water from Real Water. So Real Water would give a credit to Nevada Beverage for us to put it on the pumps and give it for free. So remember I said, one of the things we do now is give some free product out. Well, wherever that manufacturer is, there were actually 2 different waters on that coupon beside a free fountain drink. Those manufacturers of that bottle would give us a credit to Nevada Beverage, which would then give us a credit because we only deal with Nevada Beverage. So that basically they're supplying the free drinks. They get some promotion from us on that. And we get the benefit of having them giving us some free drink that we then give out to our customer. But they are not a major part of the sales of Terrible Herbst. They're not even, as I said, a top 5, top 6, 7 of the brands. And secondly, the other way around. We're not a major part of the total sales of Real Water. Terrible Herbst probably is somewhere, I think you'll hear from the testimony, in the 2% of the total sales of Real Water. Terrible Herbst is about 2% of their total sales, so pretty modest percentage. The marketing plan, where they said, there was Terrible Herbst had a good turnout. Remember, you saw that from there in they showed you the marketing plan, and one of the companies that was helping with marketing said, we did a promotion at Terrible Herbst, it went well. Well, yeah, we're a customer to them for getting this stuff out. So we're a customer of theirs. We're not a marketing arm. There's actual marketing companies that market, that are listed in the plan to do marketing, that market to companies by us. We're a customer of theirs, not a marketing arm. And by the way, we don't get anything, they don't pay us to put the ads on the pump. There's no payment for that. That's a promotional thing. It's something you get to see. Hopefully it's going to bring some people into the store because they see it bring in there. But that's not a paid for service. Now, as council mentioned, out of the 5 plaintiffs, only Mr. Hunwardsen has brought an action against Terrible Herbst. One of the others did drink, I think, water from Terrible Herbst, but only one has brought suit, which is Mr. Hunwardsen. He also brought water from Green Valley, Whole Foods, and I think he said, well, where'd you buy your water? He said, everywhere. Wherever he was, whenever he was out on a job.
Objection, Your Honor.
You all please approach, ma'am, approach us, white noise. Apologize, please. Okay, ladies and gentlemen, might take more than just a moment, okay, so what try and do is go stretch your legs. So ladies and gentlemen, recess admonishment. Anticipate 15 minutes, so to come back at 10:10. And so ladies and gentlemen, during this recess, you are admonished not to talk or converse among yourselves with anyone else on any subject connected with the trial. You may not read, watch, or listen to any report of or commentary on the trial or any person or entity connected with the trial by any medium of information, including without limitation, social media, text, tweets, newspapers, television, internet, radio. Anything I've not stated specifically is also included. Do not visit the scene or the events mentioned during the trial or the voir dire process. Do not undertake any research, experimentation, or investigation. Do not do any posting or communications on any social networking site or anywhere else. Do not do any independent research, but not including but not limited to internet searches. Do not form or express any opinion on any subject connected with the case until it's fully and finally submitted to the time of jury deliberation. With that, have a nice break, and if anybody needs to take a glass of water or anything else on the jury cart with them during their break, you should feel free to do so. Of course, you're not obligated to do so. Have a nice break, but do leave the notebooks on the chairs during the break. Thank you so much.
All right.
Okay, friendly reminder, till the jury's completely gone, the quorum requires that we all stand up. I don't think you want to be the person that the jury sees is not standing up when they're going in and out. I'm not saying who it is, just please, friendly reminder, we do appreciate it. Okay, we're now outside the presence of the jury, and so there was an issue. I'm going to let you all state what the issue was, and then ask the court what you are requesting of the court. Go ahead, counsel.
Your Honor, Costco was at one point a part of the caption in this case. There was a stipulation.
Mr. Parker, can you grab the microphone?
Oh, I'm sorry, I can move.
Yes.
There.
We do appreciate it. Thank you so much. Go ahead, please.
And in fact, part of the stipulation among the parties is the caption would be corrected. The court reminded us more than once. Ultimately, we got the caption corrected. Costco has been dismissed from this action of this matter. It should not have been brought up by Mr. Boho. Additionally, Your Honor, this is what I consider to be a backdoor attempt at addressing compensatory issues by suggesting that Mr. Hunwardsen was buying water from different locations and perhaps they're not fully responsible for his compensatory damages based on consumption of water from other locations and other stores. You know, I think it's a clear violation of the court's oral ruling yesterday. I know we don't have an order in writing yet, but clearly he understood what the court said yesterday, you know, and this has to be addressed. You know.
So, counsel, appreciate what you just said. What are you asking the court to do so that the court has an understanding that everyone can respond if they wish to do so?
First, Your Honor, I believe the objection should be sustained. Then I think that Mr. Boho or the court has to correct the record, and there has to be some reference that Costco any purchases from Mr. Hunwardsen and anyone else is not an issue in this case, that it does not diminish in any way or mitigate against Terrible Herbst's responsibility for compensatory damages.
Okay. First, we're gonna go quickly to Real Water. I don't think they have a position, but that might be the quicker version. Real Water, are you gonna wish to be heard?
Your Honor, we don't have a position on this.
Okay, no worries, then counsel for ETT, go ahead, please.
Your Honor, they showed the full caption to the jury yesterday. And then secondly, the Costco is not, I didn't ask him Costco right now on the others. I discussed Costco in relation to the testing because their expert says that testing should be done. For example, Costco does testing. That was the reason for that. That's still very much an issue in the case. And the fact that I still am entitled to do a full defense of the punitive damages aspect of the case. If any of that has any mirroring back or flashes over somehow to the other, I still am entitled to put it in the punitive damage aspect of the case. I don't know that there's anything significant on that anyway, but certainly there's nothing that I believe I've asked that isn't part of my defense of the punitive aspect of the case.
Here's what the court's gonna do. The court had an opportunity to review the actual stipulation with regards to the caption, because we can appreciate why the court wanted to review that, as I wanted to look at what was the actual language agreed upon by the parties. And since it's only 4 paragraphs, I'm gonna read them so that we're clear what it says. I'm not reading the introduction of who's representing who, that would take longer than the 4 paragraphs, so I'm just reading 4 paragraphs. 4 paragraphs. Plaintiffs have reached agreements to settle their claims against various defendants in this action. Paragraph 2. While none of these settled defendants will be participating in trial, not all of them have been formally dismissed, as some of the settlement agreements have not yet been finalized. Paragraph 3. Parties agree that the settled defendants should not appear on the caption used during trial, but they do not want to formally amend the caption to exclude defendants who have not yet been dismissed from the case. Paragraph 4. To avoid juror confusion and potential prejudice, parties stipulate and agree to use the caption attached hereto as Exhibit 1 with the jury and for all trial purposes, including but not limited to jury instructions, verdict forms, and/or anything else shown or provided to the jury. This caption is for use with the jury only and does not formally amend the caption. In this case, it's so stipulated with lots of signatures. Okay. And based on that, the order said, based on the stipulation of the parties and other good cause appearing, is hereby ordered, adjudged, and decreed that pursuant to the foregoing stipulation and to avoid juror confusion and the potential prejudice, the caption attached to the party stipulation as Exhibit 1 shall be used with the jury and for all trial purposes, including but not limited to jury instruction, verdict forms, and/or anything else shown or provided to the jury. This caption is only for use with the jury during trial and does not otherwise amend or change the caption. In this case, it is so ordered with my signature. So, the court, by the plain language of that stipulation, does not see that there was any violation by ATT's counsel, because nothing was shown that was a caption. There was nothing that said that they were or were not a party in this case. The statement with regards to Mr. Hunwardsen was an accurate statement, is that his claim against, there is a claim against him, a claim from him against Terrible Herbst. That's why Terrible Herbst are sitting here enjoying a lovely courtroom, okay? So that is an accurate statement, so the court can't find that that would be a basis for the court to sustain any objection. So then the next issue becomes is whether or not it is impermissible in light of the court's ruling yesterday, which all parties admit is not yet memorialized, but you all know in the middle of trial, everybody's allowed to follow court oral orders. I don't think anyone's going for that route, are you? Is anyone trying to contend that because the court made an oral pronouncement, somehow you don't have to follow it because it's not yet memorialized because you're right in the middle of trial?
For ETT, Dan White, no, we are not.
That's what's being applied to, so that's the one. I didn't think so, but if that was the case, then people need to get me an order in. I mean, we're trying to be accommodating during trial. Okay. That being said, I don't see it as a backdoor because I have to look at the totality of the statements that were made a few sentences before. A few sentences before, counsel for ETT basically stated that they are responsible and that he was only going to address the punitive damages. So I think that clarity aspect that was stated before, I don't see that it would be a backdoor to address what is currently stated. Of course, the court has no omniscient powers to know what people may say down the road for anyone. I don't make speculative or unright rulings, so I can't do so. So at this juncture, the court is going to overrule the objection as stated to the court based on what the court has currently heard. Now, as a friendly reminder to people, and I appreciate that there's a lot of orders in this case, but Anybody in the case got to make sure you're aware of all the orders and following them. Now, there was a statement made that in the response to plaintiff's statement, but realistically, with captions being shown, you all need to be careful not to do so. But remember, nobody raised an objection yesterday under Nevada Supreme Court precedent. That is not the type of issue that the court felt that it needed to interject itself, because remember, this was a party's stipulation. This wasn't coming really directly from the court. It was a party's stipulation. Nobody objected. The court did not find it raised to the level that the court should have intervened yesterday. So therefore, under Nevada Supreme Court precedent, at least from this court's viewpoint, raising it in response to an objection of they did it too, or they did it, and so we can do something. The court really sees that that concern would have been waived because it would have need to have been timely raised yesterday. But I am reminding everyone, and I appreciate you've got so many different things that you're trying to take care of, but everyone needs to be cognizant of stipulations. With that, that's the court's ruling. Objection overruled. Just a short version of it. I gave you the long explanation therein. So, do you all want to enjoy a few moments of a break so that if anybody needs to walk down the hall, and then we'll come back? Okay?
Thank you.
Thank you very much. Okay, so we're on the record outside the presence of the jury. I'm just going to real quickly deal with the exhibit issue. Thank you. We understand, counsel for plaintiff, you've now provided an exhibit list that includes the stipulated and pre-admitted with regards to plaintiff's proposed exhibits in your range. Is that correct?
Yes, Your Honor, except it is a joint exhibit list that contains all the parties' exhibits.
So does it include the stipulated exhibits with regards to any of the real water and ETT ones?
Yes, it includes the real water exhibits and any stipulations to the real water exhibits and the ETT exhibits and any stipulations to those.
I don't see any, so if we don't have any.
It's a joint list, so they're just by number. It includes all the parties' exhibits together.
I guess it's not a lot of them.
Okay, so I think that just really the question was, the clerk was quickly flipping through the pages. I think she only saw some on the first couple of pages appeared to only be plaintiffs, but what you're saying is if there's any stipulated admitted exhibits that were proposed by ETT or proposed by Real Water, they're also on this list, and that stipulated column has also been filled in. Is that correct?
That is correct, Your Honor.
Okay, is that good for ETT? Do you know about, are you good with this?
Yes, Your Honor.
Real Water, you good with that?
Your Honor, I think Mr. Pepperman and I need to talk further because it appears the stipulated column is blank on the one that I just received, other than it has pre-admitted. I thought there were more exhibits, but we can clear it up on it, right?
That's what the court was trying to get a clarity on, because it appeared it was only received, but, okay. So we're not gonna keep the jury out for that right now, right? Because nobody
We
needs
don't
that
need
taken
to.
care of this right now, is that correct?
Yes, we can address it later.
Okay, thank you. And I understand by agreement of the parties, counsel for ETT is gonna finish up with his opening statement and any issues are gonna be addressed afterwards, is that correct?
That is correct, Your Honor. Thank you.
Is
That
that
is
correct?
correct, Your Honor.
Okay. In Real Water, you didn't have a position, is that correct?
Correct, Your Honor.
Okay,
Your Honor, may I ask that I get a ruling of overruled so that the jury doesn't have some negative inference that we cut right in the middle of my, even though I did agree to it, but I don't want to have a negative inference on this. So I just say, the court just overruled.
what I understood is you all requested the court defer ruling on this until you conclude your opening statement, and then you could address it not at bench because you wanted to have it on the record as part of the official record. If that's not correct, then that's what I understood. So if the request is, which I've done a lot of times, and you've heard me do it even when there's been quote agreements or postponing things at bench, is I just, when you come back in and say, thank you, jury, there's nothing for the court to address at this juncture. Sorry for the interruption, counsel, move forward.
That was my understanding.
You know, I'm trying, because there were about 3 different issues raised, I think I agree in the end, sorry.
Okay,
So
no worries.
yes,
Do you want me to say that? Because I've said that lots of times, and it's basically accurate at this juncture. I say something to the effect of, thank you, ladies and gentlemen, appreciate it, hope you had a nice break, and at this juncture, there's nothing for the court to address. Sorry for the interruption.
Thank you,
And that doesn't say I'm
Yeah,
going to address
no,
something
please.
one way or another, okay?
thank you.
Does that meet your needs, counsel for plaintiff as well?
It does, Your Honor. Thank you so much.
Real Water?
Yes, Your Honor.
Okay. Marshall, please bring me in the jury. Thank you so much.
All rise for the presence of the jury.
Very nice break. At this juncture, bless you, there's nothing for the court to address, so sorry for the interruption, everyone. Counsel for plaintiff and is ready to proceed. Counsel for Real Water is ready to proceed. And counsel for ET&T, you're ready to proceed with your rest of your opening statement, correct?
I am, Your Honor.
Okay, appreciate it. Thank you. So now counsel for ET&T will continue with their opening statement. Do appreciate it.
So during the break, what I noticed, it shows you what's in our mind as we're trying to do this. The other lawyer for Real Water had the blue shirt today, and I had my blue shirt. I haven't worn a blue shirt in days, and so it just reminded me, some backhanded way to discuss what you've heard a number of times, which is each defendant is very separate. We sit on one side of the table because we're defendants, but we need to be judged like everybody else wants to be judged on their own. We are to be judged on our own, regardless of whether he and I wore blue shirts at the same time and whether we're defendants in the case. The real question here, the focus of the trial, is just as to my client, is whether or not there was a harmful act or intent to cause the injury that the time frame that you saw from Mr. Kemp with Mr. Hunwardsen was the problems that he had came on pretty quickly in September of 2019, and he had the liver transplant by 2019. So the question becomes, was there some terrible act or harmful act or intent to harm or vile act by Terrible Herbst at that time that caused that? And the answer is, this is about punitive damages now, and the answer is no, because at that time, not only was there some knowledge that we didn't impart or take action on, or some vile act by us, which is what you hear. No, by that point, by 2019, that's not the time frame that anybody knew what was going on with Real Water or the hydrazine. You'll remember the stipulation, you'll remember the statement that I read on March 13 of 2021, a year and a half later, that the FDA and the CDC and everybody was acting, and then there was the text the email that we got on March 16, that's of 2021. So at the time Mr. Hunwardsen fell ill, there was no disregard for his safety. There was no knowledge of anybody at this point, not the FDA, not the CDC, not Real Water or anyone else about the hydrazine. So that's kind of the beginning and end of all of this. The rest is just sort of things around the edges of it. So hydrazine was not known by us at that time, not known by the South Nevada Health District, not known by the FDA being in that water. Wasn't even known by Real Water. I showed you the slide of 2020, in later 2020, Blaine from Real Water, who was the vice president who did the actual concentrate, caused harm to himself in 2020, a year after Mr. Hunwardsen's problem. So he still didn't even know, or he wouldn't have been causing this to himself. We didn't know, our people were drinking that same water, whether it was at home, in the 5-gallon jugs or the other. Manufacturers generally are the ones responsible for doing the testing. The FDA goes out to food companies, the South Nevada Health Company, or Health District checks into that. None of them were checking for hydrazine in this water. So this $200 test that you heard about, well, why don't you do a $200 test? Don't know, I'm waiting to see, and we'll see what the evidence actually shows, were people doing, was a $200 test, a routine test being done on water of this type? And I believe the answer is going to be no, nobody knew anything about a $200 test. And if there was a test, that test should be done at the Real Water end, where they're actually making that product, not the 16,000 products that we sell in a store. We also, Mark, you want to bring this on? And thank you for helping. We honestly wouldn't have the expertise. We wouldn't have the ability to properly monitor what testing is good or good for 16,000 different products of every type in a convenience store. Now, you saw, here's the things we didn't know about. So we didn't know how you would use all of this. I'm going to just show you these for a minute and then get them back. these are involved in the water. You're hearing about this. We didn't know anything about this or that. If you'd flip to our store, flip to the next slide. You know what I mean?
Please, thanks, sir.
Thank you. You see the difference between, flip back one more time, look at how the real water was done versus how things are handled in a Terrible Herbst store. They're maintained, they're a bright store, they're maintained, they've got that flag in the beginning, so I showed you, some of you may know that, that's how you can tell if there's a herb store nearby. You usually look and see that they tend to put flags high in the air. Next, 2020 outbreak. You heard about that. Well, that's, the 2020 outbreak is after 2019. So we couldn't have done anything that was that caused something by our conduct to Mr. Hunwardsen in 2019, because nobody knows about it until sometime in 2020 that they're getting information, and March 13th to when the FDA, the CDC, and the South Nevada Health District actually take action. Let's go, by the way, to a lot of time was spent on wrong answers, where the answer to remember the things about the discovery, you're given discovery and testimony at trial. Was there information, did you give the wrong information with regard to prior contacts between Terrible Herbst and Real Water? And they said, they misrepresented a lot of things. I think you will hear when you actually see the people on the stand that everybody, when they gave each bit of their testimony, testified honestly to the best of their knowledge. What happened is, and you will hear this, the evidence on all of this, is a search was done. You have to respond as to whether you have documents or not. Everybody had done a search, and it had been done globally through a litigation software, ESI, that went out and dug into all, instead of individual people trying to tell you what discovery, what documents you have or not, the head of IT at Terrible Herbst did a global search for all of anything that had either the words I think real water or real or water individually. In other words, real water together and real water individually. I believe that's how he did it. I just know that they searched real water. And these didn't come up. On his global search, there is no archive feature. On the individual people, after a certain amount of emails, it goes into archiving. From what the head of IT understood from the documentation from Microsoft, when he did a search, he doesn't have that the archive button. When he did it, he didn't pull that information. It was learned very recently, like within the last couple of weeks, an individual director within the marketing department, the internal marketing, meaning for products at Terrible Herbst, for the pump and for coupons and things like that. She was on a Mac because she was creative. Everybody else was on a PC. A couple of the creatives had Macs. When she did the search, she pulled up a document that hadn't been pulled on the master search. So Terrible Herbst went in, dug into it, and then did a second search that somehow was able to dig in to all the individual archiving. So they got documents late, within the last, 10 days, 12 days. Does that reflect poorly on Terrible Herbst, my client? I think it does. If you don't get it, it's your job to get this done right. But when we found it, we turned it immediately over. There were 290 pages of one kind of emailer, not including chains, so that is true that they got information late that was inconsistent with earlier information. Now, they've had a chance to look at it. There's a slide or two, I think they may have shown it here. They've talked with the people in a court setting as to what exactly happened, so they do know all of this. So when they were telling you the information that was given was untruthful or little bad words about it, it was always, each time somebody gave that, and you'll judge this yourself on the stand to the extent they want to ask any of this, but Each time they said this is the truth, that was what they believed to be the truth based on a search, a global search by the head of IT. And the head of IT is a highly qualified person. You will see that. You'll make your own judgment. I can say it, but you're going to judge yourself as to what you think of it. And when they found that there was an archiving that didn't show on the global, that has it on individual machines, we turned it over. There's no document, there's no smoking gun that I'm aware of in there. We'll see what they say on it, but none of it changes any of the facts here that nobody at the time in September of 2019 knew anything about the hydrazine being in the water. Nobody knew it was a danger. Terrible Herbst certainly knew less than real water, which itself didn't know by then because Blaine continued to make it and continued to drink it. Thank you for listening.
Okay. Well, ladies and gentlemen, Jerry, as you know, we stated after opening statements that the next section would be the case in chief of plaintiffs. So at this juncture, counsel for plaintiff, would you like to call your first witness?